In South Carolina, premises liability law is based on the idea that as a property owner, one must protect visitors from any dangers on the property, but just to the extent that a responsible person would protect visitors. Imagine that a person trips on a broken stair that leads into a restaurant, and that person breaks an ankle. The injured person then discovers that the stair had been broken for several weeks. Under the law of premises liability in Greenville, South Carolina, if a person is injured while on the property of another person, that property owner may be held responsible if the accident is found to be caused by the negligence of the property owner. Failure to fulfill such responsibility is considered negligent, and victims are entitled to seek compensation for lost wages, hospital bills, and any other expenses. Some hazards are usually more obvious than others. For instance, a great deal of ice at the entrance of a property should easily be noticed and addressed by the owner of the property, or a building that is on the verge of collapse should also be noticed and attended to by the owner. If a property owner knows that a hazard exists but does not address it or is delayed in fixing it, the owner is legally liable for another person's injuries. But if the owner has taken reasonable steps to take care of the hazard but an injury still occurred, then the owner might be able to deny liability for the incident. For instance, if adequate warning signage is posted by a wet floor, but someone still slipped on the wet floor, the injured person may have a good case. If one is injured on someone else's property, including restaurants and stores, it is important to have a dedicated premises liability lawyer on your side with which to discuss the details of the accident and resultant injury. Brumbach & Langley, LLC can help. We are familiar with the law around this complex issue and will put our knowledge to work to ensure you receive fair and full compensation. Contact us today for a 100% free consultation.